The main objectives are to ensure social justice, economic equality, and industrial peace. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Constitution and Labor Law. 1. Regulatory framework. Labor laws in India derive authority from the Constitution. Specifically from the Union List entries 55, 61, 65, 66, 67 and the concurrent list entries 22. 24. Hence, both center and states can legislate on labor matters. Important enactments include the Industrial Disputes Act, 1947, Factories Act, 1948, Minimum Wages Act, 1948, Payment of Wages Act, 1936, and the EPF Act, 1952, all aiming to balance industrial growth with worker welfare. 2. Introduction. The Constitution forms the moral and legal base for industrial and labor laws. The main objectives are to ensure social justice, economic equality, and industrial peace. Labor laws were designed to protect weaker sections and to create balance in the employer-employee relationship. 3. Constitutional bearing on industrial laws and industrial relations. The Constitution shapes industrial relations through fundamental rights and directive principles of state policy. Together, they safeguard workers' rights, promote industrial democracy, and uphold economic justice. The focus remains on fair wages, dignity of labor, and the right to association. 4. Social justice and industrial laws. Social justice ensures fairness and equality for all workers, particularly the vulnerable. Industrial laws like the Industrial Disputes Act and Minimum Wages Act aim to achieve this through balanced and humane policies. Case law. Crown Aluminium Works vs. Workman 1958. The court observed that resolving industrial disputes should not just settle arguments but bring real justice to workers. It emphasized that industrial law must protect fairness and dignity at work. Case law. State of Mysore vs. Workers of Gold Mines 1958. The court held that social justice must be dynamic and evolve with society's needs, not remain fixed or rigid. 5. Constitutional remedies. Articles 32 and 226. Articles 32 and 226 allow workers or unions to approach the Supreme Court or High Courts when their fundamental rights are violated. Writs like mandamus or certiorari can be issued against illegal dismissals or discrimination. This ensures that labor rights are not mere ideals but enforceable protections. Advocate Anwar M, Quereshi AQ Associates. Palakkad. 6. Fundamental rights and industrial relations. Fundamental rights provide the legal foundation for industrial democracy and workers' dignity. They allow freedom of association, protection from discrimination, and security of livelihood, forming the moral code behind all labor legislation. Article 14. Equality before law. Article 14 guarantees equality before the law and protection against arbitrary actions by employers or the state. Case law. E.P. Royappa vs. State of Tamil Nadu 1974. The court famously said that equality and arbitrariness are enemies. When an employer or government acts arbitrarily, it violates equality. The case made equality a living principle of fairness. Case law. Air India vs. Nirgish Mirza 1981. The court struck down rules forcing female air hostesses to retire earlier on marriage, calling them discriminatory and unconstitutional. Article 16. Equality of opportunity in public employment. Article 16 ensures fairness in government and public sector jobs. From recruitment to promotion. Case law. Randir Singh vs. Union of India 1982. A driver in the police department fought for equal pay as his counterparts in other departments. The court ruled that equal pay for equal work is part of the constitutional guarantee of equality, turning an economic idea into a legal right. Article 19(1)(c). Right to form association and union. This article grants workers the right to form associations and trade unions but allows reasonable restrictions under Article 19(4). Case law. All India Bank Employees Association vs. NI. Tribunal 1962. The court clarified that forming a union is a constitutional right, but that doesn't automatically include the right to strike. It protected organization, not disruption. Case law. Kameshwar Prasad vs. State of Bihar 1962. Government employees were punished for peaceful demonstrations. The court held that peaceful protest is part of the right to association, as long as it doesn't disturb public order. Article 21. Right to life and personal liberty. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Article 21 extends to the right to live with dignity, health, and livelihood. Not just survival. Case law. Olga Tellis vs. Bombay Municipal Corporation 1985. Pavement dwellers argued that eviction would destroy their only livelihood. The court agreed, declaring that the right to life includes the right to livelihood. Case law. Consumer Education and Research Center vs. Union of India 1995. The court said that workers exposed to hazardous industries must be provided health care and insurance. The right to health is part of the right to life. Case law. MC. Mehta vs. State of Tamil Nadu 1996. The court held that employing children in hazardous industries violated their dignity and right to life, and directed their rehabilitation. Articles 23 and 24. Right against exploitation. Article 23 prohibits forced labor, and Article 24 bans child labor under 14 years in dangerous occupations. Case law. People's Union for Democratic Rights vs. Union of India 1982. Laborers at an Asian Games project weren't paid minimum wages. The court held that even economic pressure can amount to forced labor, making non-payment a constitutional violation. Case law. MC. Mehta vs. State of Tamil Nadu 1996. The court directed the government to end child labor and create funds for their rehabilitation, marking a milestone in protecting child rights. 7. Labor laws and directive principles of state policy DPSPs. Directive principles are not enforceable but guide the state to promote social and economic justice. Articles 38 to 43A form the ethical backbone of labor welfare, encouraging fair wages, humane working conditions, and worker participation in management. 8. Social order based on socio-economic justice. Article 38. Article 38 instructs the state to promote the welfare of the people and reduce inequalities. It supports laws like the EPF Act, ESI Act, and Minimum Wages Act, which create a fair social order through financial and social protection. 9. Equal pay for equal work. Article 39D. Article 39D directs the state to ensure equal pay for equal work, regardless of gender or role. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Case law. Randir Singh vs. Union of India 1982. The court recognized equal pay as a fundamental right flowing from equality. It became a constitutional principle across all employment sectors. Case law. McKinnon McKenzie and Company vs. Audrey DaCosta 1987. Female stenographers were paid less than men for identical work. The court ruled in their favor, calling wage discrimination unconstitutional. 10. Social Security Provisions. Articles 41, 42, 43, 43b. These articles ensure protection for workers against sickness, old age, maternity, and unemployment. Acts like ESI Act 1948, EPF Act 1952, Maternity Benefit Act 1961, and Payment of Gratuity Act 1972 bring these rights to life. They reflect the state's duty to secure a minimum standard of dignity and well-being for every worker. 11. Working Conditions. Article 42. Article 42 directs the state to ensure humane working conditions, particularly for women and children. The Factories Act, 1948, fulfills this through safety, health, and welfare provisions. Case law. MC. Mehta vs. State of Tamil Nadu 1996. The court emphasized that children and workers must not be treated as machines. It laid detailed steps to abolish child labor and improve workplace safety. 12. Living Wage. Article 43. Article 43 aims at a living wage that provides more than survival. It covers health, education, and a decent standard of life. Case law. Standard Vacuum Refining Company vs. Workman 1960. The court explained that a minimum wage sustains life, a fair wage maintains efficiency, but a living wage enables a worker to live with dignity and happiness. 13. Workers' Participation in Management. Article 43A. Added by the 42nd Amendment 1976, this article mandates workers' involvement in management decisions. It promotes cooperation through works committees and joint management councils under the Industrial Disputes Act, 1947. The idea is to replace confrontation with partnership and achieve true industrial democracy. Checkmark. Important case law summary for last-minute revision. Concept. Case. Principle. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Social Justice. Crown Aluminium Works vs. Workmen. Industrial adjudication must ensure social justice. Equal pay. Randir Singh vs. Union of India. Equal pay is a fundamental right. Forced labor. PUDRV. Union of India. Non-payment of minimum wages equals forced labor. Right to livelihood. Olga Tellis vs. BMC. Livelihood is part of life under Article 21. Right to health. CERCP. Union of India. Health and safety are part of Article 21. Child labor. MC. Mehta vs. Tamil Nadu. Child labor violates dignity and right to life. Workers' participation. Article 43A. Foundation of industrial democracy. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Evaluation of labor legislation and need of labor code. 1. Regulatory framework. India's labor legislative framework has evolved under constitutional authority. Labor falls under the concurrent list entry 22. 24, meaning both center and state can make laws. However, due to the overlap of multiple laws, the system became complex, confusing, and outdated, leading to the introduction of 4 Consolidated Labor Codes 2019. 2020. 2. Introduction. Labor legislation in India was initially designed to protect workers from exploitation and ensure social justice in industrial settings. Post-independence, laws were enacted in a piecemeal manner, often overlapping and inconsistent. Hence, a codified, simplified, and uniform legal structure became essential for clarity and compliance. 3. History of labor laws. Early labor laws were influenced by British colonial policies, like the Factories Act of 1881, which aimed to regulate working hours. After independence, the focus shifted from employer protection to worker welfare. Seen through the Industrial Disputes Act 1947, Minimum Wages Act 1948, and ESI Act 1948. By 2019, India had over 40 central labor laws, creating procedural burdens for industries. Thus, the labor codes were introduced to unify and modernize this system. 4. Need to bring in new legislations. 1. Multiplicity of laws. 44 central plus 100 plus state laws created contradictions. 2. Ease of doing business. Investors faced compliance chaos. 3. Digital India and simplification. Needed e-governance and single registration. 4. Worker protection gaps. Informal workers and gig economy lacked social security. 5. COVID-19 crisis highlighted the need for flexible, uniform labor regulation. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Hence, the 4 labor codes consolidated all major laws into one legal structure for transparency and ease. 5. Purpose of labor legislation. Protect the economic, social, and human rights of workers. Prevent exploitation and promote industrial peace. Implement DPSP's directive principles. Ensuring humane conditions and living wage. Articles 38, 39, 41. 43A. Bridge the gap between employers and employees through legal standards. Case law. In Crown Aluminium Works vs. Workman 1958, the Supreme Court observed that industrial law must not only decide disputes but also ensure social justice, balancing the scales between rich employers and poor workers, much like a referee ensuring fair play in an unequal match. 6. Classification of labor laws in India. Labor laws in India are broadly classified into 1. Protective laws. Safeguard working conditions, e.g. Factories Act, 1948. 2. Wage-related laws. Ensure fair remuneration, e.g. Minimum Wages Act, 1948. 3. Social security laws. Provide safety nets, e.g. ESI, EPF, gratuity. 4. Industrial relations laws. Manage disputes e.g. Industrial Disputes Act, 1947. 5. Welfare and equality laws. Promote dignity and gender equality e.g. Maternity Benefit Act, 1961. 7. Objective of new labor codes. To simplify, rationalize, and consolidate existing laws. Promote ease of doing business without compromising worker rights. Introduce uniform definitions e.g. wages, employee, establishment. Bring informal, gig, and platform workers under formal protection. Ensure social security coverage and single window compliance. 8. Features of new labor codes. 1. Single registration, single return, and single license system. 2. Uniform definition of wages across all codes. 3. Digitization of compliance, inspection, and registration. Advocate Anwar M, Quereshi AQ Associates. Palakkad. 4. Fixed-term employment recognized with full benefits. 5. Empowerment of women workers to work in all sectors, including night shifts. 6. Dispute resolution mechanisms made time-bound. 9. Acts subsumed by the 4 labor codes. A Code on Wages, 2019. Merges 4 acts. 1. Payment of Wages Act, 1936. 2. Minimum Wages Act, 1948. 3. Payment of Bonus Act, 1965. 4. Equal Remuneration Act, 1976. B. Industrial Relations Code, 2020. Merges 3 acts. 1. Trade Unions Act, 1926. 2. Industrial Employment Standing Orders Act, 1946. 3. Industrial Disputes Act, 1947. C. Code on Social Security, 2020. Merges 9 acts, including EPF Act, 1952. ESI Act, 1948. Maternity Benefit Act, 1961. Payment of Gratuity Act, 1972. D. Occupational Safety, Health and Working Conditions Code, 2020. Merges 13 acts, including Factories Act, 1948. Mines Act, 1952. Contract Labor Act, 1970. Interstate Migrant Workmen Act, 1979. Advocate Anwar M, Quereshi AQ Associates. Palakkad. 10. Reforms proposed by new labor codes. Single authority for compliance. Decriminalization of minor offenses. Social Security Fund for unorganized and gig workers. Gender equality in wages and opportunities. Simplified retrenchment and closure procedures for small industries. E-inspection and transparency mechanisms. 11. Code on Social Security, 2020. Extends social protection to gig, platform, and unorganized workers. Consolidates laws related to maternity, EPF, ESI, gratuity, and compensation. Introduces Aadhaar-based registration for workers and employers. Section 6. Social Security Fund creation. Case insight. During COVID-19, the plight of migrant workers revealed the urgent need for a unified welfare framework. This code directly addresses that gap. 12. Occupational Safety, Health and Working Conditions Code, 2020. Ensures safe and humane working environments. Covers all sectors. Factories, mines, docks, plantations, construction, etc. Provides free annual health checkups and gender-neutral workplaces. Section 6. 13. Duties of employers to maintain safety standards. MC. Meta versus State of Tamil Nadu 1996 inspired many safety provisions. The court stressed that employers have an absolute duty to ensure worker safety, much like guardians ensuring no child is left unprotected in a dangerous zone. 13. Code on Wages, 2019. Establishes a universal minimum wage applicable across all industries. Mandates equal pay for equal work irrespective of gender. Introduces floor wage fixed by the central government. Section 2I. Uniform definition of wages. Randhir Singh vs. Union of India 1982. Recognized equal pay for equal work as a constitutional right. The code makes this principle legally enforceable in a uniform way across India. 14. Industrial Relations Code, 2020. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Promotes industrial harmony through dialogue and conciliation. Recognizes fixed-term employment and allows voluntary arbitration. Provides for speedy dispute resolution and digital registration of trade unions. Chapter 2. Recognition of negotiating unions. Chapter 7. Retrenchment, layoff, and closure provisions simplified. Bangalore Water Supply v. A. Rajappa 1978. Expanded the definition of industry. The code builds upon this spirit by balancing flexibility with fairness, like turning a chaotic orchestra into a disciplined symphony. Checkmark key case laws for quick revision. Concept. Case. Story explanation. Social justice. Crown Aluminium Works vs. Workman 1958. The court acted as a referee ensuring fairness between powerful employers and weaker workers. Equal pay. Randhir Singh vs. Union of India 1982. A driver in Delhi police fought for equal wages. SC upheld his right under Art. 14 and 39D. Industrial definition. Bangalore Water Supply v. A. Rajappa 1978. Even a club was held to be an industry since it involved organized work and workers. Safety at work. MC. Meta vs. State of Tamil Nadu 1996. After child labor deaths, SC declared worker safety a constitutional duty of employers. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Law of Welfare and Working Condition. Unit I. Factories ACT, 1948. 1. Regulatory Framework. The Factories Act, 1948 is a social welfare legislation enacted to ensure health, safety, welfare, and proper working conditions of workers in factories. It derives authority from entry 24 of the concurrent list. Both center and state can make rules. The Act extends to the whole of India and applies to all manufacturing establishments meeting the definition of a factory. 2. History of the legislation. The first Factory Act was enacted in 1881 under British rule to protect child labor in textile mills. Subsequent amendments 1891, 1911, 1934 gradually improved working conditions. After independence, the Factories Act, 1948 replaced the 1934 Act, incorporating international standards from the ILO International Labour Organization to ensure worker welfare and safety. 3. Object of the Act. The main objective is to ensure 1. Health, safety, and welfare of workers. 2. Regulation of working hours and employment of women and children. 3. Promotion of industrial efficiency through better working conditions. Essentially, it humanizes industrial environments by treating workers as human beings, not machines. 4. Applicability of the Act. Applicable to all factories. Using power and employing 10 or more workers, or not using power but employing 20 or more workers. Section 2 meters. Applies to the whole of India. Does not apply to mines, armed forces, or railway running sheds. 5. Scheme of the Act. Advocate Anwar M, Quereshi AQ Associates. Palakkad. The Act is divided into 11 chapters and 120 sections, broadly covering 1. Preliminary definition Sec. 2. Inspecting staff and powers Sec. 7. 10.3. Health, safety, and welfare provisions Sec. 11. 54. Working hours and employment regulations Sec. 51. 66.5. Penalties and procedures Sec. 92. 106. 6. Definitions Section 2. The Act defines key terms essential for applicability. Worker Sec. 2L. Factory Sec. 2 meters. Occupier Sec. 2N. Manufacturing process Sec. 2K. Group relay shift Sec. 2R. 7. Worker. Section 2L. A worker means any person employed, directly or through an agency, with or without remuneration, in any manufacturing process, cleaning, or incidental work related to it. It includes contract laborers but excludes members of the armed forces. Case law. In Shankar Balaji Wahe vs. State of Maharashtra 1962, a watchman guarding factory premises was held to be a worker because his duty was essential to the factory's functioning, even though he didn't handle machinery directly. 8. Factory. Section 2 meters. A factory is any premises where 10 or more persons are working with power, or 20 or more without power, and where a manufacturing process is carried on. Case law. Advocate Anwar M, Quereshi AQ Associates. Palakkad. In Ardashir H. B. Wandawala vs. State of Bombay 1961, a salt works using seawater evaporation was held to be a factory. The court said manufacturing need not involve complex machinery. Even natural processes count. 9. Occupier. Section 2N. An occupier means the person who has ultimate control over the factory's affairs. In a company, any director is deemed the occupier. In a partnership, one partner. In government factories, appointed officer. Case law. In Indian Oil Corporation vs. Chief Inspector of Factories 1998, the company nominated its site manager as occupier. The Supreme Court held that only a director can be the occupier, ensuring accountability at the top level, not delegation to subordinates. 10. Exemption of occupier or manager from liability Sec. 101. If the occupier or manager can prove due diligence and identify the actual offender, they may be exempted from punishment. The burden lies on the accused to show good faith and proper supervision. 11. Group relay shift. Section 2R. A group or relay means workers engaged in the same kind of work and working in different shifts to ensure continuous operation. The purpose is to regulate working hours and rest intervals uniformly. 12. Statutory agencies and their powers Sec. 7. 10. Authorities. 1. Inspectors of factories. Ensure compliance, inspect records, and issue directions. 2. Certifying surgeons. Examine health fitness of workers, especially women and young persons. 3. Chief Inspector. Supervises statewide enforcement and prosecutions. Advocate Anwar M, Quereshi AQ Associates. Palakkad. They have the power to enter, inspect, photograph, seize documents, and issue improvement notices. Case law. In Bikusa Yamasa Kshatriya vs. State of Maharashtra 1963, the court upheld the wide powers of factory inspectors, emphasizing that prevention of accidents must take priority over commercial convenience. 13. Duties of occupier manufacturer Sec. 7a. Every occupier must ensure safety and absence of health risk, proper maintenance of machinery, training and supervision. Safety policy must be displayed and updated. Manufacturer must design machinery with adequate safety guards. 14. Measures for health, safety and welfare Sec. 11. 50. The Act mandates that factories maintain basic human standards. Clean, safe, and healthy workplaces. 15. Health Sections 11. 20. Provisions include cleanliness Sec. 11. Factory premises to be clean, whitewashed, and disinfected. Ventilation and temperature Sec. 13. Adequate air and comfortable temperature. Dust and fume control Sec. 14. Exhaust systems to prevent inhalation. Lighting Sec. 17. Proper natural artificial light. Drinking water Sec. 18. Safe, cool water supply. Latrines and urinals Sec. 19. Separate for men and women. Case law. In State of Gujarat vs. Pradham Singh Narsingh Parmar 2001, the court held that poor sanitation and ventilation in a factory violated worker health rights, emphasizing that health protection is as vital as wages. 16. Safety Sections 21. 41. Includes Advocate Anwar M, Quereshi AQ Associates. Palakkad. Fencing of machinery Sec. 21. Employment of young persons on dangerous machines Sec. 23. Hoists and lifts Sec. 28. Precautions against fire Sec. 38. Safety officers in large factories Sec. 40b. Case law. After the oleum gas leak Delhi, 1986, the Supreme Court in MC. Mehta vs. Union of India evolved the principle of absolute liability. Industries dealing with hazardous materials must compensate victims, even without negligence. This case inspired stricter enforcement of safety provisions in the Factories Act. 17. Provisions relating to hazardous processes Chapter EVA, Sections 41a. 41h. Introduced after the Bhopal gas tragedy 1984 to strengthen industrial safety. Key sections. Sec. 41a. Site Appraisal Committee. Approves sites for hazardous industries. Sec. 41b. Occupier must disclose information about hazardous materials. Sec. 41c. Occupier responsible for safety systems and training. Sec. 41d. Central government can appoint inquiry committees after accidents. Sec. 41e. Power to frame emergency standards. Sec. 41f. Sets permissible limits of toxic substances. Sec. 41g. Workers' participation in safety management. Sec. 41h. Right of workers to warn about imminent danger. Case law. The Bhopal gas disaster 1984 became a turning point. Thousands died due to gas leakage from Union Carbide. The tragedy led Parliament to insert Chapter EVA, ensuring that every factory handling hazardous materials now bears strict responsibility for worker safety and disclosure. 18. Welfare Sections 42, 50. Ensures that workers enjoy minimum comfort, dignity, and hygiene. Sec. 42. Washing facilities. Separate, clean, and sufficient. Sec. 43. Storing and drying clothes for dusty or wet jobs. Sec. 44. Sitting facilities for workers required to stand. Sec. 45. First aid boxes. 1 for every 150 workers. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Sec. 46. Canteens. Mandatory wear 250 plus workers employed. Sec. 47. Shelters, restrooms, and lunchrooms. Sec. 48. Creches. Required where 30 or more women are employed. Case law. In State of Punjab vs. Labour Court 1980, a woman worker demanded a creche facility. The court emphasized that welfare provisions are not charity but fundamental rights of labor under Article 42 of the Constitution. Checkmark important sections to remember exam quick list. Concept. Section. Dash dot. Definition of worker. Sec. 2L. Definition of factory. Sec. 2 meters. Definition of occupier. Sec. 2N. Duties of occupier. Sec. 7A. Cleanliness. Sec. 11. Lighting. Sec. 17. Drinking water. Sec. 18. Fencing of machinery. Sec. 21. Fire safety. Sec. 38. Safety officers. Sec. 40B. Hazardous process. Sec. 41A. 41H. Washing facilities. Sec. 42. Canteen. Sec. 46. Creches. Sec. 48. Concept. Case. Story summary. Dash dash dot. Dash dash dot. Dash dot. Definition of worker. Shankar Balaji Wahe vs. State of Maharashtra. A watchman guarding the factory was held a worker since his duty aided manufacturing. Definition of factory. Ardashir H. B. Wandawala vs. State of Bombay. Salt making by evaporation counted as manufacturing. Thus, the place was a factory. Occupier responsibility. Indian Oil Corp. V. Chief Inspector 1998. Only a director can be an occupier. Accountability must be at top level. Safety and liability. MC. Meta vs. Union of India Oleum gas leak. Industries handling hazardous materials are absolutely liable for damage. Health and sanitation. State of Gujarat vs. Pradham Singh Parmar. Poor factory hygiene violates health provisions and worker dignity. Welfare measures. State of Punjab vs. Labour Court. Welfare facilities are a legal right, not employer charity. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit 2. The Contract Labor Regulation and Abolition ACT, 1970. Regulatory Framework. The Contract Labor Regulation and Abolition Act, 1970 regulates the employment of contract labor in certain establishments and aims to abolish it in specific cases where it leads to exploitation. It works with the Contract Labor Regulation and Abolition Central Rules, 1971. The central and state governments share the responsibility for implementation under Article 246 and Entry 23 concurrent list of the Constitution. Purpose: to ensure fair wages, decent working conditions, and prevent the misuse of contract labor in core industrial operations. History of the legislation. Before 1970, contract laborers faced severe exploitation. Low wages, no job security, and no welfare benefits. To fix this, the Royal Commission on Labour 1931 and the Second Five-Year Plan recommended regulation. Based on these reports, Parliament passed the Act in 1970, which came into force in 1971. Case law. Standard Vacuum Refining Company vs. Their Workman 1960. The court observed that employing contract labor for regular and perennial work was an unfair labor practice, which later influenced the 1970 Act. Object and scope of the Act. The Act's main object is twofold. 1. Regulation. To ensure proper working conditions, payment, and welfare for contract labor. 2. Abolition. To prohibit contract labor in activities that are perennial or necessary to the establishment. Scope. It applies to every establishment and contractor employing 20 or more contract laborers on any day of the preceding 12 months. Sections 1. 2 define the scope and extent. Definitions. Section 2. Some key definitions to remember. Section 2b. Contract labor. Persons hired through a contractor to work in an establishment. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Section 2c. Contractor. A person who undertakes to produce a given result or supply labor. Section 2e. Establishment. Any office, shop, or industry where contract labor is employed. Section 2 grams. Principal employer. The head of the department or owner of the establishment. Case law. Hussain Bhai vs. Alath Factory Tejalali Union 1978. The court held that even if workers are employed through contractors, if the principal employer controls the work, they are the real employer for ensuring welfare benefits. The Advisory Board Sections 3. 5. The Act provides for Central Advisory Contract Labor Board and State Advisory Contract Labor Boards. Their function is to advise governments on matters related to regulation, abolition, and welfare of contract labor. They also recommend industries or operations where contract labor should be abolished. Composition. Representatives from the government, employers, contractors, and workers. Registration of establishments employing contract labor. Section 6. 12. Every establishment employing 20 or more contract laborers must be registered with a registering officer. Similarly, every contractor must obtain a license before employing contract labor. Section 7. Registration of establishment. Section 12. Licensing of contractors. Section 9. Prohibits employment of contract labor if not registered. Case law. Air India Statutory Corporation vs. United Labour Union 1997. The court held that when contract labor is abolished, the workers should be absorbed by the principal employer, recognizing their right to livelihood and security. Welfare and health of contract labor. Section 16. 21. The Act mandates several welfare facilities. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Section 16. Canteen facilities where 100 plus workers are employed. Section 17. Restrooms. Section 18. First aid facilities. Section 19. Drinking water, latrines, and urinals. Section 20. Liability of the contractor to provide these. Section 21. Responsibility of the principal employer to ensure payment of wages and welfare compliance. Case law. Workmen of Best and Crompton Industries vs. Management 1994. The court emphasized that contract laborers doing the same work as regular employees are entitled to the same wage and welfare benefits. Penalties and procedures. Sections 23. 26. Violations such as employing contract labor without registration, non-maintenance of facilities, or non-payment of wages attract penalties. Section 23. Contravention of provisions. Punishable with imprisonment up to 3 months or fine up to 1,000 rupees, or both. Section 24. Offenses by companies. Section 25. 26. Procedure for prosecution and cognizance. Inspecting staff. Sections 28. 30. Inspectors are appointed by the government to ensure compliance with the Act. They have powers to enter any premises, examine records, question any person, seize or copy relevant documents. Inspectors ensure that wages are paid properly, facilities are maintained, and labor welfare standards are met. Registers and other records to be maintained. Sections 29. 30 and Rules 75. 82. Both principal employers and contractors must maintain registers such as Register of Contractors Form 12. Register of Workers Employed Form 13. Wage Register Form 17. Muster Roll Form 16. Advocate Anwar M, Quereshi AQ Associates. Palakkad. These records help the inspectors verify compliance and ensure accountability in case of disputes. Checkmark key points to remember for exams. Applicability. 20 or more contract laborers. Principal employer. Ultimately responsible for welfare and wages. Sections to recall. 2 definitions, 7 registration, 12 licensing, 16. 21 welfare, 23 penalties. Important case laws. Standard Vacuum Refining Company. Unfair labor practice. Need for legislation. Hussain by case. Real employer concept. Air India case. Absorption after abolition. Best and Crompton case. Equal benefits principle. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit 3. The Child and Adolescent Labor Prohibition and Regulation ACT, 1986. Regulatory framework. The Child and Adolescent Labor Prohibition and Regulation Act, 1986 was enacted under Article 24 of the Constitution, which prohibits employment of children below 14 years in factories, mines, or hazardous jobs. It was amended in 2016 to include adolescents 14, 18 years and rename the Act to its current form. The central and state governments share enforcement responsibility under Entry 23, Concurrent List. Introduction. The Act aims to prohibit employment of children and regulate working conditions of adolescents in non-hazardous jobs. It seeks to protect children from physical and mental exploitation while ensuring their right to education under Article 21A and right to life under Article 21. It complements the National Policy on Child Labor 1987 and the Right of Children to Free and Compulsory Education Act, 2009. Definition. Section 2. Child. A person who has not completed 14 years of age. Adolescent. A person who has completed 14 years but is below 18 years. Establishment. Includes shop, commercial place, workshop, or any premises where a process is carried out. Family enterprise. Work conducted by family members, except hazardous processes. These definitions are crucial for identifying whether employment is legal or prohibited under the Act. Prohibition of employment of children in any occupations and processes. Section 3. No child below 14 can be employed or permitted to work in any occupation or process. Exception. Helping in family enterprises after school hours or during vacations, provided it is non-hazardous. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Also, children can work as artists in entertainment or sports not in circuses under specific conditions. Case law. MC. Meta vs. State of Tamil Nadu 1996. The Supreme Court directed the government to identify and withdraw child workers from hazardous industries, provide education, and rehabilitate them through a welfare fund created from employer contributions. Prohibition of employment of adolescents in hazardous occupations and processes. Section 3A. Inserted by the 2016 amendment, this section prohibits employment of adolescents in hazardous occupations and processes listed in the schedule, e.g. mining, explosives, chemical factories. The government can revise the list periodically through notifications. Case law. Bachpan Bachao Andolan vs. Union of India 2011. The Supreme Court held that employing children and adolescents in hazardous jobs violates their fundamental right to life and education. The court ordered stricter enforcement and periodic inspections. Hours and period of work. Section 7. Adolescents employed in non-hazardous work cannot work for more than 3 hours continuously without rest, work more than 6 hours a day, work between 7 p.m. and 8 a.m. and be required to work overtime or in multiple establishments. This ensures protection of their health and mental well-being. Weekly holidays. Section 8. Every adolescent worker is entitled to one whole day holiday each week, preferably Sunday. Advocate Anwar M, Quereshi AQ Associates. Palakkad. This aligns with International Labour Organization ILO conventions emphasizing rest and recreation for young workers. Notice to Inspector. Section 9. Every employer must give a written notice to the inspector within 30 days of employing an adolescent containing name and address of establishment, details of the worker, and nature of work assigned. This allows authorities to monitor and ensure compliance with the Act. Maintenance of register section 11. Every employer must maintain a register with details like name, date of birth, and working hours of each adolescent, nature of employment, and intervals of rest. The register must always be available for inspection by government officials. Display of notice containing abstract of sections 3A and 14 section 12. Employers are required to display a notice in a visible place at the workplace containing an abstract of section 3A. Prohibition of adolescent employment in hazardous work. Section 14. Penalties for contravention. This serves as a constant reminder and public notice of legal duties and penalties. Penalties Section 14. Employing a child right pointing arrow imprisonment up to 2 years and or fine up to 50,000 rupees. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Employing an adolescent in hazardous work right pointing arrow same penalty as above. Repeat offenders right pointing arrow stricter imprisonment. Parents employing children in family enterprises are exempt unless habitual violators. Case law. People's Union for Democratic Rights vs. Union of India 1982. The Supreme Court ruled that employing children in construction work for the Asian Games violated Article 24 and directed strict enforcement of child labor laws. District Magistrate to implement the provisions Section 17A. Inserted by 2016 Amendment. The District Magistrate is designated as the key authority for implementing this Act. They supervise inspections, register offenses, and ensure rehabilitation of rescued children through coordination with welfare boards and NGOs. Checkmark key points to remember for exams. Main sections. 2 definitions, 3 prohibition of child labor, 3A adolescent prohibition, 7 working hours, 9 notice, 11 register, 14 penalties, 17A district magistrate role. Constitutional support. Articles 21, 21A, 23, 24, and 39E and FDPSP. Important case laws. MC. Mehta vs. State of Tamil Nadu 1996. Rehabilitation and Education Fund. Bachpan Bachao Andolan vs. Union of India 2011. Ban on hazardous jobs for children. PUDRV. Union of India 1982. Child labor equals violation of fundamental rights. Amendment year. 2016. Extended protection to adolescents. Exam tip. Always mention right to education art. 21A and ILO Convention number 138 and 182 for international context. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Lesson 17. Law of Industrial Relations. Unit I. Industrial Disputes ACT, 1947. Regulatory Framework. The Industrial Disputes Act, 1947 ID Act provides the legal mechanism to prevent and settle disputes between employers and workmen. It applies to the whole of India, ensuring industrial peace, fair negotiation, and social justice. The Act empowers the central and state governments concurrent list, entry 22 to handle disputes through conciliation, adjudication, and arbitration. Introduction. Before 1947, industrial disputes were handled under Trade Disputes Act, 1929, which lacked enforcement power. After independence, the Industrial Disputes Act was enacted to ensure industrial harmony and collective bargaining between workers and employers. Object and significance of the Act. To promote industrial peace and productivity. To ensure fair investigation and settlement of disputes. To protect workmen from arbitrary dismissal and exploitation. To encourage conciliation before conflict. Case law. Western India Automobile Association vs. Industrial Tribunal 1949 Air 111. This was the first major case interpreting the Act. The Supreme Court emphasized that the Act's goal is not punishment but reconciliation and justice. Important definitions Section 2. The Act contains several crucial definitions that form the base of every exam question. Industry Section 2J. Originally defined very broadly as any business, trade, or manufacture. After much confusion, the Supreme Court in Bangalore Water Supply and Sewerage Board vs. A. Rajappa 1978 Air 548 laid down the famous triple test. 1. Systematic activity, Advocate Anwar M, Quereshi AQ Associates. Palakkad. 2. Cooperation between employer and employee. 3. For production distribution of goods or services. Story style note. In this case, even a charitable organization was held to be an industry because it employed people systematically. Industrial Dispute Section 2K. Any dispute or difference between employers and employers, employers and workmen, or workmen and workmen, concerning employment, terms, or conditions of labor. Case law, Bombay Union of Journalists vs. State of Bombay 1964. The court held that the dispute must be real and supported by a substantial body of workmen, not an individual grievance unless espoused by a union. Workman Section 2S. A workman means any person including apprentices employed for manual, technical, or clerical work, but not those in managerial or administrative capacity. Case law, HR, Adayanthaya vs. Sandoz India Limited. 1994 Air 2608. Engineers and supervisors earning high salaries were held not to be workmen, as they performed mainly managerial functions. Strike Section 2Q. A strike means a cessation of work by a body of workmen acting together as a form of protest against the employer. It is a powerful tool for collective bargaining. Types of strikes and their legality. 1. General strike, large-scale protest by many industries. 2. Stay and sit-down strike. Workers occupy the workplace. 3. Go slow strike, deliberate slowdown of work. 4. Hunger strike, fasting in protest. 5. Sympathetic strike, support for other workers. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Illegal strikes, if conducted in violation of Sections 22, 24, especially during conciliation or without proper notice for public utility services. Case law, All India Bank Employees Association vs. NI, Tribunal 1962 Air 171. The court held that while the right to form a union is fundamental, the right to strike is not a fundamental right. Legality of strike Sections 22, 24. A strike is illegal if commenced without notice in public utility services, during conciliation or adjudication proceedings, in contravention of government orders under Section 10(3). Case law, TK, Rangarajan vs. Government of Tamil Nadu 2003-6 SC 581. The court held that government employees have no legal or moral right to strike, as it disrupts public welfare. Lockout Section 2L. A lockout is the employer's counterpart to a strike, the temporary closing of a workplace to pressure workers. Legal lockouts must follow proper notice under Section 22. Case law, Management of Carebetta Estate vs. Rajamanikam 1960 Air 893. The Supreme Court held that a lockout in response to a strike could be justified if done to protect business interests. Layoff Section 2 KKK. Temporary inability of employer to give work due to shortage of raw materials, machinery failure, etc. Section 25C. Workmen are entitled to 50% wages during layoff. Case law, Workmen of Firestone Tire and Rubber Company vs. Management 19731 SC 813. Layoff must be for genuine and unavoidable reasons. Otherwise, compensation is payable as if retrenchment occurred. Retrenchment Section 2U. Termination of service of a workman by employer for any reason other than punishment. Advocate Anwar Masiha Quereshi AQ Associates. Palakkad. Section 25F. Employer must give 1 month's notice, 15 days average pay for every completed year, prior intimation to the government. Case law, State Bank of India vs. N. Sundara Money 1976 Air 1111. Even termination due to automation or redundancy counts as retrenchment unless Section 25F conditions are met. Award Section 2B. A decision of an industrial tribunal, labor court, or arbitrator resolving a dispute. It becomes enforceable 30 days after publication by the government. Appropriate government Section 2A. Determines whether central or state government handles the dispute. Central government, for industries like railways, banking, mines. State government, for all other industries within the state. Average pay Section 2 AAA. Refers to the average of wages payable during the preceding 3 months. Used to calculate compensation for retrenchment, layoff, or closure. Closure Section 2 CC. Permanent closing down of a place of employment. Section 25 FFA. 60 days notice required before closure. Section 25 FFF. Compensation similar to retrenchment. Advocate Anwar Masiha Quereshi AQ Associates. Palakkad. Controlled Industry Section 2D. Industries declared by the central government under Section 2 of the Industries Development and Regulation Act, 1951. Employer Section 2 grams. A person or authority having ultimate control over the affairs of the establishment. Includes agents or managers. Public Utility Service Section 2N. Includes railways, postal, water, electricity, and similar essential services. Notice of strike lockout 14 days mandatory under Section 22. Settlement Section 2P. A written agreement between employer and workman arrived at through conciliation or direct negotiation. Binding on all parties once signed and registered. Trade Union. Although governed by the Trade Unions Act, 1926, the ID Act recognizes unions as a collective voice representing workmen in disputes and settlements. Unfair Labor Practice Section 2 RA and Schedule 5. Acts by employers or workmen that hinder free collective bargaining, such as victimizing union members, instigating illegal strikes, interfering with union formation. Advocate Anwar Masiha Quereshi AQ Associates. Palakkad. Case law, Bharat Iron Works vs. Bhagubhai Patel 1976 Air 98. The court held that victimization or unfair dismissal due to union activity is an unfair labor practice. Wages Section 2 RR. All remuneration expressed in money payable to a workman, excluding bonuses and contributions to Provident funds. Authorities under the Act and their duties Sections 3. 9. 1. Works Committee. Employer and worker representatives to promote good relations. 2. Conciliation Officer. Attempts to settle disputes amicably. 3. Board of Conciliation. Investigates disputes and suggests settlement. 4. Labor Court Tribunal National Tribunal. Adjudicate matters based on severity and scope. Reference of disputes Sections 10. 12. Government can refer disputes to Labor Court. For matters in Schedule 2 e.g. dismissals. Industrial Tribunal. For Schedule 3 wages, hours, bonus. References can be voluntary Sec. 10A or compulsory. Voluntary reference to arbitration Section 10A. Employers and workmen may voluntarily refer disputes to an independent arbitrator. Award by arbitrator is binding and published by the government. Strikes and lockouts Sections 22. 24. Regulate legality, procedure, and timing of strikes and lockouts. Prohibit such actions during conciliation or adjudication. Unfair labor practices Section 25T. 25U. Prohibits both employers and workers from committing unfair labor practices. Punishment Sec. 25U. Imprisonment up to 6 months or fine up to 1,000 rupees. Advocate Anwar Masiha Quereshi AQ Associates. Palakkad. Penalties Sections 25Q. 25U. Illegal strike lockout right pointing arrow fine or imprisonment. Failure to implement award right pointing arrow punishable. Repeated violations right pointing arrow higher penalties. Checkmark key case law summary quick revision table. Concept. Case. Principle. Dash dot. Dash dash dot. Dash dash dot. Industry definition. Bangalore Water Supply v. Rajappa 1978. Triple test. Systematic activity, cooperation, goods services. Strike right. All India Bank employees vs. NI. Tribunal 1962. Right to form union does not equal right to strike. Retrenchment. SBIV. Sundara Money 1976. Retrenchment covers all terminations. Layoff. Workmen of Firestone Tire 1973. Genuine reason needed. Unfair labor practice. Bharat Iron Works vs. Bhagubhai Patel 1976. Victimization equals unfair practice. Government employees strike. TK. Rangarajan vs. TN Government. 2003. No legal right to strike. Checkmark important sections to remember. 2J, 2K, 2S. Industry, dispute, workmen. 22. 24. Strikes and lockouts. 25F. 25FFF. Retrenchment and closure. 25T. 25U. Unfair labor practices. 10. 10A. Reference and arbitration. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit 2. The Industrial Employment Standing Orders Act, 1946. Regulatory Framework. The Industrial Employment Standing Orders Act, 1946 IESO Act was enacted to bring uniformity in service conditions of workmen and reduce disputes. It applies to industrial establishments employing 100 or more workers adjustable to 50 under some state amendments. It empowers the central and state governments to oversee certification and enforcement of standing orders. Object and scope of the Act. Ensure clarity and transparency in employment terms. Avoid arbitrary action by employers. Covers conditions like classification of workmen, wages, leave, termination, and disciplinary procedures. Provides legal backing for disciplinary actions. Exam tip. Think of it as the rulebook of industrial employment. Important definitions Section 2. Employer. Person controlling establishment. Workman. Any person employed in an industrial establishment, excluding managerial staff. Industrial establishment. Any factory, mine, plantation, workshop, or place where goods are manufactured or processed. Standing orders. Rules governing conditions of employment, duties, and rights of workmen. Appellate authority Section 8. An authority designated by the appropriate government to hear appeals against certifying officer decisions. Case law. Hindustan Steel Works vs. State of Bihar 1962 Air 178. Court held that appellate authority must ensure fair hearing and procedural compliance before certifying or modifying orders. Appropriate government Section 2A. Advocate Anwar M, Quereshi AQ Associates. Palakkad. The central government or state government authorized to enforce the Act, depending on the industry's location and sector. Certifying officer Section 3. Officer appointed to certify draft standing orders submitted by employers. Ensures orders comply with model standing orders and reasonable employment conditions. Case law. Bharat Heavy Electricals Limited vs. Union of India 1988. The Supreme Court emphasized that certification should not be denied arbitrarily if draft orders meet statutory requirements. Employer. Responsible for preparing, submitting, and implementing standing orders. Must ensure compliance and fairness in application. Industrial establishment. Covers factories, mines, plantations, and any industrial premises where workmen are employed. Standing orders. Legally binding rules covering classification of workmen, permanent, probation, apprentices. Working hours, leave, holidays. Disciplinary rules and termination procedures. Grievance redressal. Wages and workmen. Wages include basic pay, allowances, and must comply with minimum wages legislation. Workmen must be clearly defined to distinguish managerial or supervisory staff. Certification of draft standing orders. Employers submit draft orders to the certifying officer Sec. 3. Officer checks reasonableness and compliance with model standing orders. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Orders may be approved, modified, or rejected. Case law. Steel Authority of India vs. Union of India 1995. Certification ensures both employer and workman rights are balanced. Arbitrary rejection can be challenged in court. Submission of draft standing orders by employers Section 3. Employers must submit draft orders within 6 months of applicability of the Act. This ensures timely clarity on service conditions. Conditions for certification of standing orders Section 4. Must be reasonable, clear, and fair. Cannot contravene any labor law or fundamental right. Fairness or reasonableness of standing orders. Cannot be oppressive or discriminatory. Covers termination, disciplinary actions, dispute resolution, and wage rules. Case law. Bajaj Auto Limited vs. Workman 1978. The court stressed that orders must protect workers from arbitrary dismissal and uphold industrial harmony. Certification of standing orders. Once certified, the orders become binding on all workmen in the establishment. Any modifications require fresh certification. Appeals Sections 8. 9. Workman or employer may appeal against certifying officer's decision. Appellate authority examines fairness and compliance with the law. Date of operation of standing orders. Certified orders are effective from the date specified by the certifying officer. Advocate Anwar M, Quereshi AQ Associates. Palakkad. All employers must implement the orders immediately. Posting of standing orders Section 6. Orders must be displayed prominently in the workplace. Ensures all workers are aware of rules. Duration and modification of standing orders Section 7. Standing orders remain valid for 12 months or until modified. Employers can request modification based on changing industrial conditions. Payment of subsistence allowance Section 7A. In case of suspension, workmen are entitled to subsistence allowance during the period of inquiry. Ensures protection against financial hardship during disciplinary proceedings. Interpretation of standing orders Section 12. Certifying officer or labor courts can interpret ambiguous clauses. Interpretation must favor fair treatment of workmen. Case law. Hindustan Motors vs. State of WB 1984. Courts interpret standing orders liberally in favor of workmen if any ambiguity exists. Temporary application of model standing orders Section 5. If draft orders are not submitted within 6 months, model standing orders apply automatically. Ensures no gap in regulation and workers' rights are protected. Matters to be provided in standing orders Schedule 1. Classification of workmen, permanent, probation, apprentice. Working hours, holidays, leave, and wage provisions. Shift and rest period rules. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Suspension, dismissal, and disciplinary procedures. Grievance redressal mechanisms. Checkmark important sections to remember. 2. Definitions. 3. Submission and certification of draft standing orders. 4. Conditions for certification. 5. Temporary application of model orders. 6. Posting of orders. 7. Modification and duration. 7A. Subsistence allowance. 8. 9. Appeals. 12. Interpretation. Checkmark key case law summary for last minute revision. Concept. Case. Principle. Dash dash dot. Dash dash dot. Appellate authority. Hindustan Steel Works vs. Bihar 1962. Fair hearing must be ensured. Certification of Orders. BHELV. Union of India 1988. Certification cannot be arbitrarily denied. Reasonableness. Bajaj Auto vs. Workman 1978. Standing orders must protect workman rights. Interpretation. Hindustan Motors vs. WB 1984. Ambiguities interpreted in favor of workers. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit I. Payment of Wages ACT, 1936. Regulatory Framework. Applies to workers earning up to the wage ceiling prescribed by the state central government. Ensures timely payment of wages without unauthorized deductions. Object and scope. Ensure prompt payment of wages to workers. Prevent exploitation and arbitrary deductions. Definition Sec. 2. Wages. All remuneration capable of being expressed in money, excluding bonus, allowances, and overtime. Employer. Person responsible for payment of wages. Worker. Any person employed in industry, factory, mine, plantation, or other establishments. Responsibility for payment of wages Sec. 3. Employer is primarily responsible for wage payment. Fixation of wage period Sec. 4. The wage period is the interval for which wages are calculated. It can be weekly, bi-weekly, or monthly, as fixed by the employer. Important point. The wage period must be consistent and clearly communicated to employees. Wages must be paid weekly, bi-weekly, or monthly as fixed by the employer. Time payment of wages Sec. 5. Wages must be paid on the due date of the wage period. Delay in payment is considered a violation under the Act. Prevents financial hardship to workers and ensures stability. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Wages must be paid on time, without unreasonable delay. Mode of payment Sec. 6. Coin, currency notes, check, or bank credit. Protects workers from inaccessibility of wages. Deductions Sec. 7. Authorized deductions include income tax, fines, provident fund, absence from work, etc. Excess or unauthorized deductions are legal. Fines Sec. 7.3. Employer can fine only as per standing orders or legal provisions. Registers and records Sec. 8. Employer must maintain records of wages, deductions, and payments. Claims and penalties Sec. 9 to 14. Worker can claim unpaid wages before the inspector authority. Penalty for malicious or vexatious claims is also prescribed. Case law story style. K. Verma vs. Union of India 1968. Employer delayed payment of wages. The court emphasized prompt payment is a statutory obligation, not a discretionary act. Key points to remember. Sec. 5. Timely payment. Sec. 6. Mode of payment. Sec. 7. Deductions. Sec. 8. Maintenance of registers. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit 2. Minimum wages ACT, 1948. Regulatory framework. Ensures minimum wages to workers in scheduled employment. Object and scope. Protect workers from exploitation. Fix minimum wage based on skill, time, and industry. Important definition Sec. 2. Appropriate government 2B. Central or state government fixing minimum wages. Employee 2I. Any person employed in scheduled employment. Employer 2E. Person responsible for payment. Scheduled employment 2 grams. Employment specified by government in the schedule. Wages 2I. All remuneration capable of being expressed in money. Fixation and revision of minimum wages Sec. 3. 5. Minimum rates fixed by government notification. First method Sec. 5.1a. Cost of living plus fair wage. Second method Sec. 5.1b. Based on prevailing wages. Revision at intervals of not more than 5 years. Advisory Board Sec. 7. 10. Central Advisory Board and State Advisory Boards advise on fixation and revision. Payment and working hours. Payment must be in cash or check Sec. 12. Normal working day fixed by Sec. 13. Overtime paid as per Sec. 14. Wages for partial day or piecework calculated under Sec. 15 and 17. Registers and records Sec. 18. Employers must maintain minimum wages register. Authority and claims Sec. 20. 21. Inspector authority resolves claims and disputes regarding wages. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Case law story style. Chandigarh Transport Undertaking vs. Employees 1972. Court held that failure to pay minimum wages even due to ignorance of law is a violation. Employer cannot escape liability. Key points to remember. Sec. 3. Fixation of minimum wages. Sec. 12. Payment obligatory. Sec. 13. 14. Normal working day and overtime. Sec. 18. Registers. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit 3. Payment of bonus ACT, 1965. Regulatory framework. Ensures statutory bonus to employees in profit-making establishments. Object and scope. Encourage profit sharing and industrial harmony. Applicable to establishments with 20+ employees. Application and exemptions. Covers private and public sector establishments. Certain employees excluded based on salary ceiling or managerial position. Important definitions. Accounting year. Financial year of the company. Allocable surplus. Profit available for bonus. Available surplus. Amount after statutory allocations. Employee and employer. As per Act. Calculation and eligibility. Bonus equals 8.33% to 20% of salary wages depending on profit and productivity. Eligibility requires working 30+ days in accounting year. Bonus linked with production or productivity. Some establishments can link bonus with output to incentivize efficiency. Power of exemption Sec. 32. Government can exempt certain establishments or employees. Penalties and offenses. Non-payment or delayed payment attracts penalty and prosecution. Case law story style. Sundaram Finance Limited vs. Employees 1988. Court held that bonus is a statutory right, cannot be waived even if employment contract is silent. Employers must calculate bonus from allocable surplus. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Key points to remember. Sec. 3. Applicability. Sec. 8. Calculation of bonus. Sec. 32. Power of exemption. Eligibility. 30 days minimum service. Checkmark quick exam summary. Act. Key sections. Key takeaways. Case law example. Dash dash dot. Dash dash dot. Dash dot. Payment of Wages Act. Sec. 5, 6, 7, 8. Timely payment. Mode. Authorized deductions. Registers. K. Verma vs. Union of India. Prompt payment mandatory. Minimum Wages Act. Sec. 3, 5, 12, 13, 14, 18. Fixation, revision, payment, working hours, registers. Chandigarh Transport Undertaking. Minimum wage violation is liability. Payment of Bonus Act. Sec. 3, 8, 32. Eligibility, calculation, government exemption. Sundaram Finance. Bonus statutory right, must be paid. Here's a complete exam-oriented brief explanation of Equal Remuneration Act, 1976 and Social Security legislations. Including all headings, important sections, definitions, case law story style, and key points to remember. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit IV. Equal Remuneration Act, 1976. Regulatory framework. Enacted to prevent gender-based discrimination in remuneration and employment. Applicable to all establishments employing both men and women workers. Object and scope. Ensure equal pay for equal work for men and women. Prevent discrimination in recruitment, training, promotion, and remuneration. Definition Sec. 2. Employee. Person employed for wages. Employer. Person responsible for payment of wages. Work. Any job or task requiring similar skill, responsibility, and effort. Act to have overriding effect Sec. 3. Overrides any inconsistent provisions in other laws or agreements. Duty of employer to pay equal remuneration Sec. 4. Employer must pay equal wages to men and women for same or similar work. Includes remuneration for overtime, incentive, and bonus. Discrimination not to be made in recruitment Sec. 5. Men and women must have equal opportunity in recruitment and training. Authorities for hearing claims Sec. 6. Purpose. To provide a mechanism for workers to raise complaints about unequal pay or discrimination in recruitment between men and women for the same work or work of similar nature. Authorities. The state government appoints inspectors or other authorities to receive complaints, investigate, and take action. Procedure. 1. Worker or employer can submit a complaint regarding contravention of the Act. 2. The authority can inquire, summon witnesses, and direct the employer to pay equal remuneration or correct discriminatory practices. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Penalty. If the employer fails to comply, they can be punished with fines under the Act. Maintenance of registers Sec. 7. Employer must maintain registers of employees, wages, and equal pay compliance. Penalty Sec. 8. Fine up to 10,000 rupees for violation. Repeated violation attracts higher penalties. Case law story style. Randir Singh vs. Union of India 1982. A female employee challenged lower pay compared to male colleague. Court emphasized that equal remuneration is a fundamental right under the Act and must be strictly followed. Key points. Sec. 4 and 5. Equal pay and non-discrimination. Sec. 6. Authorities for complaints. Sec. 7. Registers maintenance. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Lesson 19. Social Security legislations. Unit I. Employees State Insurance Act, 1948 ESI. Regulatory framework. Provides social security to workers in case of sickness, maternity, disablement, and employment injury. Introduction. Funded by contributions from employer and employee. Ensures healthcare, cash benefits, and rehabilitation. Important definitions Sec. 2. Appropriate government. Government authority to implement scheme. Confinement. Childbirth. Contribution. Amount payable by employer-employee. Dependent. Family member eligible for benefits. Employment injury. Injury arising during employment. Employee. Person employed in insured establishment. Exempted employee. Certain categories excluded. Principal employer, immediate employer. Responsible for registration and contributions. Insurable employment. Employment covered under Act. Insured person. Employee eligible for ESI benefits. Permanent partial total disablement. Extent of injury determining compensation. Sickness, temporary disablement. Temporary inability to work. Seasonal factory family wages. As defined under Act. Registration of factories and establishments. Mandatory registration. Factories or establishments employing 10 or more persons in some states, threshold may be 20 and insurable employment must register with the ESI authorities. Insurable employment generally includes employees whose wages do not exceed 21,000 rupees per month as per latest amendment, check state notifications. Purpose. Ensures that all eligible employees are covered for medical care, sickness, maternity, and disablement benefits. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Section to remember. Sec. 6. Registration of factories and establishments. All eligible establishments must register and contribute to the ESI fund. Administration of ESI scheme. Employees State Insurance Corporation ESIC manages funds, benefits, and compliance. Regional boards and standing committees supervise operations. Medical Benefit Council manages healthcare provisions. Employees State Insurance Fund. Fund created for medical, sickness, maternity, disablement, and dependent benefits. Contributions recovered from employer first, then immediate employer. Benefits. Medical care, cash sickness benefit, maternity benefit, disablement benefit, dependence benefit. Employees Insurance Court. Handles disputes relating to benefits, contributions, and claims. Case law story style. Dharamendra Kumar vs. ESI Corporation 1995. A worker injured on duty claimed compensation. Court held that ESI provides statutory right to medical and cash benefits, enforceable through ESI court. Key points. Registration and contribution mandatory. Medical and cash benefits to insured persons. ESI court handles disputes. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit 2. Employees Provident Funds and Miscellaneous Provisions ACT. 1952 EPF. Regulatory framework. Ensures retirement benefits, pension, and insurance for employees in factories establishments. Introduction and application. Covers establishments employing 20+ employees, with exemptions for smaller or specified establishments. 1. Mandatory registration of establishments. Minimum employees. Any establishment with 20 or more employees must register under the EPF Act. Type of employees covered. All employees drawing basic wages is less than or equal to 15,000 rupees per month as per latest amendment. Earlier 15,000 rupees. Exempted employees. Employees in certain establishments exempted by central government notification. 2. Sections to remember. Sec. 1. Short title, extent, commencement. Sec. 2. Definitions. Employee, employer, establishment, wages, etc. Sec. 5. Application of the Act to establishments. Sec. 6. Employees to be members of the fund. 3. Key points. Contribution as employer. 12% plus employee. 12% of basic wages. Some exemptions for small establishments. Provides Provident Fund, pension scheme, and deposit-linked insurance scheme. Registration is compulsory. Non-registration leads to penalties and liability to pay contributions with interest. 4. Case law story style for memory. Regional PF Commissioner versus MSXYZ Private Limited. A company tried to avoid registration for its 25 employees. The court held that registration is mandatory for all establishments with 20+ employees, even if some employees earn slightly above 15,000 rupees basic wages. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Important definition. Sec. 2. Appropriate government. Authority to implement PF and pension schemes. Basic wages. All remuneration excluding bonuses, overtime, or allowances. Employer-employee. As defined for contribution purposes. Exempted employee. Exemption of establishments. Certain employees' establishments can be exempted. Factory fund, industry insurance fund, pension scheme, superannuation scheme. All is defined in Act. Schemes under the Act. 1. Employees Provident Fund Scheme. Long-term savings for employees. 2. Employees Pension Scheme. Retirement pension for employees. 3. Employees Deposit-linked insurance scheme. Life insurance benefit. Determination and recovery of monies due. Employer must deposit contributions timely. Government can recover dues from employer or employee. Priority given to PF contributions over other debts. Protection of employees. Employer cannot reduce wages to avoid contributions. Transfer of accounts on changing employment. Attachment protection. PF amount protected from creditors. Power to exempt. Appropriate government can exempt certain establishments or employees from schemes. Case law story style. P. K. Sinha vs. EPFO 2002. Employee claimed PF contribution was not credited. Court held that employer's statutory duty is absolute. Contributions cannot be denied, even if employee is unaware. Key points. Mandatory contribution by employer and employee. Schemes. PF, pension, insurance. Protection from wage reduction and attachment. Recovery powers for authorities. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Checkmark quick exam summary table. Legislation. Key sections. Key takeaways. Case law example. Dash dot. Dash dash dot. Equal Remuneration Act, 1976. Sec. 4, 5, 6, 7, 8. Equal pay, no gender discrimination, registers, complaint authorities. Randhir Singh. Equal pay is statutory right. ICSI Act, 1948. Sec. 2, 37, 41. Medical and cash benefits, employer contribution, registration. Dharamendra Kumar. Injured worker entitled to ESI benefits. EPF Act, 1952. Sec. 2, 6, 8, 12, 14, 17. Provident Fund, pension, insurance, employer contribution, recovery. P. K. Sinha. Employer duty to deposit PF is absolute. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit 3. Maternity Benefit Act, 1961. Regulatory Framework. Sec. 1. Enacted under Article 42 of the Constitution, promoting social justice and humane conditions of work. Objective. Protect the health and employment rights of women during maternity, ensure paid leave, and job security. Introduction. Provides maternity leave, benefits, and safe working conditions for women employees. Covers all establishments employing 10 or more persons, factories, shops, establishments, educational institutions, hospitals, etc. Focuses on reducing maternal and infant mortality and promoting women's welfare at workplace. Definition. Sec. 2. Employee. Woman employed for wages in any establishment. Employer. Person responsible for paying maternity benefits. Maternity benefit. Leave and cash payment granted to women employees for childbirth, miscarriage, or illness related to pregnancy. Important section to remember. Sec. 2 definitions form the foundation for applicability. Employment of or work by women prohibited during certain periods. Sec. 3. Women cannot work 6 weeks before and after childbirth. Exception. Women can work before childbirth with her consent, provided the nature of work is not hazardous. Key point. Health and safety of mother and child is prioritized. Right to payment of maternity benefits. Sec. 5. Employee is entitled to full wages during maternity leave, 26 weeks for first 2 children, 12 weeks for subsequent children. Includes leave for miscarriage, medical termination of pregnancy, and illness arising out of pregnancy. Employer must pay maternity benefit directly to employee. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Case law. Gujarat Bottling Company vs. Workman 1987. Denial of maternity leave and payment to a woman employee was held illegal. Court emphasized statutory right cannot be waived. Notice of claim for maternity benefit. Sec. 6. Woman employee must give written notice to employer specifying expected date of delivery. Purpose. Allows employer to plan work and comply with statutory obligations. Nursing breaks. Sec. 11. Employer must allow 2 breaks per day for feeding the child, up to 15 months of age. Important point for exam. Sec. 11 ensures continuity of employment and health of mother and child. Creche facility. Sec. 12. Establishments employing 50 or more women must provide creche facilities. Women allowed 4 visits per day to the creche to attend their child. Abstract of Act and rules thereunder to be exhibited Sec. 7. Employer must display abstract of the Act and rules in a conspicuous place in the workplace. Ensures awareness among employees about their rights. Registers Sec. 8. Employers must maintain a maternity register containing names of women employees, date of commencement of maternity leave, payment of maternity benefits, date of resumption of work, purpose, inspection and compliance, penalty for contravention of Act by employer Sec. 15. Employer violating any provisions can be fined up to 5,000 rupees. Key sections attracting penalties. Sec. 3, 5, 11, 12, 7, 8. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Case Law. R.K. Agarwal vs. Union of India 1990. Employer delayed maternity benefit. Court held that employer must pay benefit promptly. Failure attracts penalty under Sec. 15. Exam-oriented important points. 1. Mandatory sections. 2 definitions, 3 prohibited work, 5 payment, 11 nursing breaks, 12 creche, 7 display, 8 registers, 15 penalty. 2. Leave period. 26 weeks for first 2 children, 12 weeks thereafter. 3. Applicability. All establishments with 10 plus employees. 4. Rights. Paid leave, nursing breaks, job security, creche facility. 5. Penalties. Fine up to 5,000 rupees. Repeated violations attract prosecution. 6. Case laws. Highlight non-waivable rights, prompt payment, employer liability. Here's a brief, exam-oriented explanation of all headings under the Payment of Gratuity Act, 1972, including sections, key points, and relevant case laws. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit IV. Payment of Gratuity Act, 1972. Regulatory Framework Sec. 1. Enacted under Article 41 Right to Work, Social Security and Article 42 Humane Working Conditions of the Constitution. Provides social security to employees by guaranteeing gratuity payment on termination of employment after continuous service of 5+ years. Introduction. Ensures a lump sum benefit to employees as a token of gratitude for long-term service. Covers private sector establishments, factories, shops, and government employees. Application of the Act Sec. 1 and 2. 1. Applicability minimum employees. The Act applies to every establishment employing 10 or more employees Sec. 1 2. Includes factory, mine, oil field, plantation, port, railway company, shop or other establishment. Employees covered. Any employee who has rendered continuous service of 5 years or more Sec. 4. Exemptions can be granted by appropriate government. Who is an employee? Sec. 2e. Any person employed on wages in an establishment for 12+ months. Excludes apprentices and certain contractual employees. Other important definitions Sec. 2. Employer. Person responsible for paying gratuity. Family. Includes spouse, children, dependent parents, and children of predeceased children. Continuous service. Includes leave, layoff, or strike period Sec. 2e. Wages. Basic pay plus dearness allowance excluding bonus, overtime, or allowances. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Appropriate government Sec. 2c. Determines application and enforcement of the Act in its jurisdiction. Can exempt establishments or issue rules for payment and recovery. Continuous service Sec. 2e. Minimum 5 years of service required to qualify for gratuity. Service break due to strike, layoff, or maternity leave is counted as continuous. Family Sec. 2f. Defines eligible family members who may receive gratuity in case of employee death. Retirement superannuation. Gratuity payable on retirement, superannuation, resignation, death, or disablement. Wages Sec. 2s. Basic plus dearness allowance. Excludes overtime, bonus, and allowances. When is gratuity payable? Sec. 4. Employee eligible after 5 years of continuous service. Exceptions. Death or disablement. Gratuity payable even if service less than 5 years. To whom is gratuity payable? Sec. 4. To employee or family members in case of death. Amount of gratuity payable Sec. 4. Formula. Last drawn wages times 15 to 6 times number of years of service Fraction of 6 months equals considered as full year. Nomination Sec. 6. Employee can nominate family members to receive gratuity. Nomination can be changed anytime during employment. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Forfeiture of gratuity Sec. 4-5. Gratuity can be forfeited for acts of willful misconduct, fraud, or violent behavior. Case law. State Bank of India vs. S.N. Bhattacharya 1989. Gratuity was forfeited for gross misconduct. Courts held employer must prove misconduct. Exemption Sec. 1 and Rule 2. Small establishments may be exempted by appropriate government. Government employees covered under separate schemes. The Controlling Authority and Appellate Authority Sec. 7 and 8. Controlling Authority. Supervises payment of gratuity in disputes. Appellate Authority. Hears appeals against decisions of Controlling Authority. Rights and obligations of employees. Right to receive gratuity within 30 days of termination. Must submit nomination and claim for payment. Application for payment of gratuity Sec. 4 and 7. Employee applies to employer directly or controlling authority if employer fails to pay. Rights and obligations of the employer. Duty to compute, determine, and pay gratuity. Must maintain registers and records of gratuity paid. Employer's duty to determine and pay gratuity Sec. 4 and 7. Employer must pay gratuity within 30 days of termination. Late payment attracts interest at prescribed rate. Dispute as to amount or admissibility of gratuity Sec. 7. If dispute arises, employee can approach controlling authority. Authority may decide claims and issue direction for payment. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Case law. LIC of India vs. Manu by 1980. Court upheld controlling authority's decision on calculation of gratuity. Employer must comply. Recovery of gratuity Sec. 7. Controlling authority can recover gratuity due along with interest from employer. Employer liable even if establishment transferred or closed. Protection of gratuity. Gratuity cannot be attached, assigned, or used as security under Sec. 7.3. Ensures gratuity is protected for employee family. Exam-oriented important points. 1. Mandatory sections. 2. Definitions. 4. Payment and calculation. 6. Nomination. 7. Controlling authority. 8. Appeal. 2. Eligibility. Minimum 5 years service, but death or disablement equals immediate entitlement. 3. Payment period. 30 days after termination. Late payment attracts interest. 4. Exemptions. Small establishments, government employees under other schemes. 5. Forfeiture. Only for willful misconduct, fraud, or violence. 6. Case laws. Highlight employer liability, calculation, and proof of misconduct. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit V. Apprentices Act, 1961. Regulatory framework. Enacted under Article 19(1) Graham right to practice any profession and Article 41 Social Security. Promotes skill development, vocational training, and employability of youth. Introduction. The Act regulates the training of apprentices in industries. Ensures structured training combining practical and theoretical knowledge. Applicable to factories, establishments, and industries notified by central state government. Definition Sec. 2. Apprentice. Person engaged for training under a contract. Contract of apprenticeship. Written agreement between employer and apprentice. Designated trade. Trades notified for apprenticeship. Optional trade. Trades approved for training beyond designated trades. Establishment employer. Any industry or establishment employing apprentices. Authorities. Central Apprenticeship Council, State Apprenticeship Advisor, etc. Qualifications for being engaged as an apprentice Sec. 7. Must have minimum educational qualifications for the designated trade. Age limit. Generally 14. 35 years depending on trade. Must be physically fit to undergo training. Contract of apprenticeship Sec. 6. Written agreement specifying duration, stipend, training, rights and duties. Mandatory registration with appropriate authority. Novation of contracts of apprenticeship. Substitution or amendment allowed with mutual consent and approval of authorities. Ensures continuity of training if employer changes. Regulation of optional trade. Employers may offer training in optional trades if capacity permits. Duration and syllabus approved by Apprenticeship Council. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Engagement of apprentices from other states. Apprentices can be recruited across states for training, subject to approval by the authority. Period of apprenticeship training Sec. 10. Minimum period, 6 months. Maximum, 3 years. Specific period fixed for each trade. Number of apprentices for a designated trade and optional trade Sec. 10. Maximum apprentices equals 1:5 ratio to number of skilled workers in trade. Ensures proper training without overcrowding. Practical and basic training of apprentices Sec. 9. Training is dual. 1. Practical training. Hands-on in workplace. 2. Basic training. Classroom instruction, theory. Obligations of employers Sec. 12. Provide structured training, stipend, safe working conditions. Facilitate basic training and evaluation. Maintain records of attendance, performance, and stipend. Obligations of apprentice Sec. 13. Attend practical and theoretical training regularly. Abide by discipline and instructions of employer. Not misuse knowledge gained during training. Hours of work, overtime, leave and holidays Sec. 14. Maximum 8 hours per day or 48 hours per week. Eligible for weekly holidays, casual leave, and paid leave as per establishment rules. Overtime should not exceed legal limits. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Apprentices are trainees and not workers Sec. 2 and 12. Apprentices do not have worker rights under labor laws except Social Security if specified. Stipend provided as training allowance, not wage. Records and returns Sec. 18. Employers must maintain registers of apprentices. Personal details. Attendance and performance. Stipend paid. Annual returns to be submitted to authorities. Settlement of disputes Sec. 16. Disputes regarding training, stipend, or termination resolved by Apprenticeship Advisor. Central State Apprenticeship Council. Holding of test and grant of certificate and conclusion of training Sec. 17. Apprentices appear for trade test at the end of training. Certificate issued on successful completion. Completion does not guarantee employment, but enhances employability. Offer and acceptance of employment. Employer may offer employment post-training. Acceptance voluntary, not mandatory under the Act. Authorities under the Act Sec. 4 and 19. Central Apprenticeship Council. Advises government on policy. State Apprenticeship Advisor. Supervises implementation. Employers and principals. Ensure training compliance. Offense and penalties Sec. 22. Non-compliance failure to provide training, maintain registers, or submit returns attracts. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Fine up to 10,000 rupees per violation. Repeated default may attract further penalties. Exam-oriented important points. 1. Sections to remember. 2. Definitions, 6. Contract, 9. Training, 10. Period and number, 12. 13. Obligations, 16. 17. Dispute and certificate, 22. Penalty. 2. Key concept. Apprentices equals trainees, not employees, receive stipend not wages. 3. Training ratio, 1. 5. Apprentice. Skilled worker. 4. Dual training, practical plus basic. 5. Completion certificate, enhances employability. 6. Authorities. Central and State Apprenticeship Councils plus Apprenticeship Advisor. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Unit V. Labor Law Simplification of Procedure for Furnishing Returns and Maintaining Registers by Certain Establishments ACT. 1988. Regulatory Framework. Enacted under Article 19(1) Graham Right to Practice Profession and Article 41 Social Security. Objective. Reduce administrative burden on small and very small establishments by simplifying the maintenance of returns and registers required under multiple labor laws. Introduction. Many labor laws require periodic filing of returns and maintenance of registers by employers. This act provides exemptions and simplified procedures for certain categories of establishments, mainly small and very small ones. Ensures compliance without undue bureaucratic burden. Definition Sec. 2. Employer. Person who employs workers in any establishment. Establishment. Includes factory, industry, workshop, shop, or any other workplace where labor laws apply. Form. Any form prescribed for maintaining returns and records under the Act. Scheduled Act. Labor legislation listed in the schedule of this Act for which simplified procedures apply. Small establishment. Establishment with up to 19 workers varies by state rules. Very small establishment. Establishment with up to 9 workers. Exemption from furnishing or maintaining of returns and registers required under certain labor laws Sec. 3 and 4. Small and very small establishments may be exempted wholly or partially from maintaining certain registers and filing returns under scheduled acts. Central or state government issues notifications specifying which establishments are exempt. Registers returns exempted. Conditions to be fulfilled. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Furnishing or maintaining of returns and registers in electronic form Sec. 5. Employers may maintain records electronically instead of manual registers. Facilitates easier compliance and data retrieval. Must ensure accuracy, authenticity, and security of electronic records. Penalty Sec. 6. Non-compliance with provisions. Failure to maintain registers or furnish returns as required can attract fine up to 5,000 rupees or as prescribed by government rules. Emphasis is on simplification, not punishment, so minor non-compliance may not attract strict penalties. Sections to remember. Exam focused. 1. Sec. 2. Key definitions. Employer, establishment, small very small establishment, form, scheduled act. 2. Sec. 3 and 4. Exemption provisions for small very small establishments. 3. Sec. 5. Maintenance of electronic records. 4. Sec. 6. Penalty for non-compliance. Purpose. Reduce administrative burden for small and very small establishments. Applicability. Only establishments employing up to 19 workers. Small very small. Electronic records. Allowed under Sec. 5. Aligns with modern digital compliance. Scheduled acts. Act provides exemptions without violating the underlying labor law. Penalty. Mild. Emphasizes compliance over punishment. Case laws. Illustrative example. No major landmark Supreme Court or High Court rulings specifically interpret this Act, as it primarily deals with procedural simplifications, not substantive rights. Exam tip. Focus on definitions, applicability, exemptions, and electronic maintenance. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Summary. 1. Simplifies maintenance of registers and filing returns. 2. Focused on small and very small establishments. 3. Allows electronic record keeping. 4. Exemptions and simplified procedure promote ease of compliance. 5. Penalty is minimal, reinforcing the procedural nature. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Lesson 20. Sexual Harassment of Women at Workplace Posh ACT. 2013. Regulatory Framework. Enacted under Article 15.3 empowering the state to make special provisions for women and Article 19.1 Gram right to practice profession. Provides mechanism for prevention, prohibition, and redressal of sexual harassment at the workplace. History of the legislation. Based on Vishaka Guidelines 1997 Supreme Court case Vishaka vs. State of Rajasthan. Created to legislate guidelines into statutory law, making it binding for all workplaces. Object of the Act. Prevent sexual harassment of women at workplace. Provide redressal mechanism through complaints committees. Ensure sensitive and speedy inquiry. Promote safe and dignified work environment. Forms of workplace sexual harassment. Physical contact and advances. Demand or request for sexual favors. Showing pornography or offensive materials. Sexual remarks or gestures. Hostile or intimidating environment affecting dignity. Applicability. All offices, factories, organizations, private public sector, NGOs, domestic workers, educational institutions. Women employees and contractual workers are protected. Definitions Section 2. Aggrieved woman. Woman of any age employed at workplace, or visiting, affected by harassment. Employer. Head of establishment or person responsible for management. Sexual harassment. Includes unwelcome acts behavior, whether direct or by implication, of sexual nature. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Workplace. Any site, location, or premise where employee works. Complaints Committee. Internal Complaints Committee ICC. Every workplace with 10 or more employees must constitute an ICC. Local Complaints Committee LCC. District Level Committee for workplaces with less than 10 employees or unorganized sector. Constitution Internal Complaints Committee. Headed by Woman Presiding Officer. Members include senior female employees and NGO activists with experience in women issues. Constitution of Local Complaints Committee. Constituted by District Officer. Consists of members from NGOs or experts in women welfare, ensuring independent inquiry. Grants and audit. Government may provide funding and grants to strengthen functioning of ICCs LCCs. Auditing ensures transparency and accountability. Complaint and complaint of sexual harassment. Complaint must be in writing within 3 months from the date of incident. Can be filed by aggrieved woman, legal heir, or authorized representative. Section 9. Employer must forward complaint to ICC within 7 days. Conciliation. Optional stage before inquiry. ICC may attempt amicable resolution, but no monetary settlement without consent of aggrieved woman. Inquiry into complaint Section 11. ICC conducts fair and reasonable inquiry. Both parties must be given notice and chance to present evidence. Inquiry to be completed within 90 days. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Action during pendency of inquiry. ICC may recommend transfer of aggrieved woman or alleged harasser, or grant leave to aggrieved woman. Inquiry report. ICC submits report with findings and recommendations to employer or authority. Action to be taken within 60 days after report. Punishment for false or malicious complaint and false evidence. Complaints maliciously made may attract fine up to 50,000 rupees. False evidence can also lead to disciplinary action. Determining of compensation. ICC may recommend compensation for mental trauma, loss of career opportunity, medical expenses. Prohibition of publication or making known contents of complaint and inquiry proceedings. Confidentiality is mandatory. Breach may attract penalty. Penalty for publication or making known contents of complaint and inquiry proceedings. Employer or persons found guilty may be fined under Act. Ensures protection of victim's identity. Appeal. Aggrieved party can appeal to appellate authority within 90 days of inquiry decision. Duties of employer. Provide safe working environment. Display notice of act at workplace. Constitute ICC where required. Implement recommendations of ICC. Duties and powers of district officer. Ensure LCCs are constituted and function properly. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Monitor compliance and record maintenance. Miscellaneous. ICC must submit annual report on complaints received, actions taken, and pending cases. Employer must include POSH data in annual report. Appropriate government to take measures to publicize the Act. Awareness campaigns, workshops, and training for employees and employers. Power to call for information and inspection of records. Government may inspect workplace records to ensure compliance. Penalty for non-compliance with provisions of Act. Employers failing to constitute ICC or LCC can be fined. Cognizance of offense by courts. Courts may take cognizance of offense without complaint, under Sec. 20. Act not in derogation of any other law. POSH Act supplements existing laws, does not override CRPC, IPC, or labor laws. Power of appropriate government to make rules. Rules may prescribe. Form of complaint. Procedure for inquiry. Qualification of members of ICC LCC. Manner of maintaining records. Advocate Anwar M, Quereshi AQ Associates. Palakkad. Important sections to remember. Sec. 2. Key definitions. Sec. 4. Constitution of Internal Complaints Committee. Sec. 6. Constitution of Local Complaints Committee. Sec. 9. Complaint forwarding. Sec. 11. Inquiry procedure. Sec. 13. Action during pendency of inquiry. Sec. 16. Determination of compensation. Sec. 21. Offense for non-compliance. Case law. 1. Vishaka vs. State of Rajasthan 1997. Laid down guidelines for preventing sexual harassment, forming the basis of POSH Act. 2. Medicavo Lele vs. Union of India 2012. Reinforced need for ICCs in government offices and employer accountability. 3. Preeti Radi vs. Union of India 2014. Time limit for complaint cannot be rigidly applied if woman faces obstacles. Exam points. Mandatory ICC for 10+ employees. Confidentiality is key. Breaches are punishable. Complaint within 3 months, inquiry within 90 days. Compensation for mental trauma, harassment, medical expenses. Employers, duties. Safe environment, awareness, compliance with recommendations. POSH supplements, not replaces, other laws.